Welcome to the New Civil Liberties Alliance's Lunch and Law. The surveillance state suffers defeat. No, it's not legal to track Americans 24 hours a day, 7 days a week. And I'm John Becchione. I'm Senior Litigation Counsel here at New Civil Liberties. And in the name, we have Alliance, and we have two of the allies in this case here with us. And I'm delighted to have with us Greg Grimsel, our local counsel down in New Orleans. He's a member of the law firm of Gordon, Arata, Montgomery, and Barnett. And he's been with this case from the beginning. So thank you for being here, Greg.
My pleasure.
And we have Robert Alt, president and CEO of the Buckeye Institute, who put an amicus brief in the Fifth Circuit on this case. That was, I think, also amusing, but also very good. It had many citations to fish literature. So in any event, so we're going to discuss the case of Mexican Gulf Fishing Company versus Department of Commerce today. And this case came out of the Fifth Circuit. I'll just describe it briefly. Most of you tuning in have some idea about it, but I think it's important to understand that nobody wants to leave Margaritaville on a boat with a federal monitor tracking them. And so this is what we really have here. We have charter boats who take you out fishing for a day, and they come back in. And what happened was the National Oceanic Atmospheric Administration, NOAA, the National Marine Fisheries Service, and the Department of Commerce were going to have all these charter boats have to have what they called a VMS, a vehicle monitoring system, which is government for GPS that we all would call. And you'd have to have that on there, and you'd have to send the government your position at all times. Fortunately, NCLA, on behalf of our clients, the entire class of charter boat fishermen in the Gulf, stopped them. And the Fifth Circuit issued an opinion that we're here to discuss today. And for those of you who want to take a look at it, it's Mexican Gulf Fishing Company versus Department of Commerce, 60 F 4th 956, Fifth Circuit 2023. It was written by Judge Elrod and mostly joined by Judges Richmond and Oldham. And we may discuss what parts they didn't join. But overall, a very strong opinion for constitutional rights and for the administrative state having to tell you what they're going to do before they do it to you. The charter boat captains also objected to providing proprietary information like the amount they charged, the number of passengers, what they paid for gas, not only because these are trade circuits, but because the agencies didn't give them any warning in their proposed regulations that they were going to do this. And the Fifth Circuit was blunt. They said, quote, "We conclude that in promulgating this regulation, the government committed multiple independent Administrative Procedure Act violations and very likely violated the Fourth Amendment." And so I'll just open it up. Greg, you've been involved in this case from the beginning. Why'd you think this was a good case for your firm to take pro bono?
John, well, the first thing I want to say may sound like it's a setup endorsement, but it's really not. Let me assure everybody watching this that what I'm about to say is completely unsolicited and uncompensated for. But one of the primary reasons we got involved was because it was NCLA. You have a brand, I don't know if you're aware of it now, of doing really quality work and punching well above your weight. And people are aware of, what your lane is and what your issues are. I certainly was. And so that meant a lot to me to want to get my firm involved in it. Second, fishing, there are a lot of people in my firm who fish, although I happen to be something of a landlubber and not as conversant with the fish population as many of my friends are. And as it turned out, the associate I asked to get involved is an ardent fisherman and has in her office a picture of herself holding a trout that's bigger than she is.
And so, Kate Clark, and she clerked in the Fifth Circuit. She's been extremely helpful.
Yeah, and let me give a shout out to her now. Kate Clark really brought a lot to this case. And third was, of course, the privacy facet. one of the things that got me interested about a year ago, Ronan Farrow did an article in New Yorker about an Israeli company called NSO Group that has a product called Pegasus, and they licensed this product to governments, and it enables a government to take over your phone. The government can download data from your phone. It can turn the mic on. It can turn the camera on. And that was pretty frightening. So, if you'll forgive my sort of boomer cultural reference, William F. Buckley once said that our fingertips should be tingling with concern about encroachments on our liberty. And so that's why we got involved.
Well, that's good. That was more than I expected. Thank you very much for that, Greg. But I also, and does this opinion vindicate your views?
Oh yeah, it was quite a performance. I mean, there's a lot about its love, particularly with a number of the ways in which it focused on the privacy interest. I don't know if you want to, get into that.
We'll go into it a little bit, but that's what I wanted.
That was the big thing. It really took the agency to the woodshed. I thought it sent them a very strong signal. Don't do this again.
I think that's right. And Rob, Buckeye put in an amicus, and I'll ask you the same question. You do a lot of litigation in the constitutional sphere. What was interesting to you about the case, and how do you think it turned out?
So you say that like you're thinking that Ohio wouldn't be a natural ally when it came to seafaring law, and so I just have to when the case came down, I was waiting for the quote to come from John. We have met the enemy, and they are ours. And of course, that quote is from Commodore Perry, which he uttered on after the Battle of Lake Erie in Ohio. So despite obviously there's very interesting constitutional concerns, but I think this is a case that applies even to a landlocked state in the Midwest, that has a Great Lake on its northern border. The implications are far-reaching for this kind of intrusion if the government is permitted to track that. And as I think we'll talk about later, this could jump. Had this been allowed to stand, had this privacy infringing regime been allowed to stand, we could have seen it jump the shark, so to speak, and hit land.
Or the walleye.
Here they come.
It only goes downhill from here. But so we had, I think, interests both in terms of the facts that I think we felt implicated interests in the Midwest as well as constitutional interests. So, and I would second Greg's comment. Anytime that we see an NCLA case and get a request to do an amicus brief, those are among the more interesting requests we get because you guys do such excellent work.
And I also want to say Jay Carson helped John that brief, and he's always been very helpful to us as well.
Well, Jay, and that actually is another example. Jay, much like Greg's example, Jay lives right on Lake Erie, and on most weekends you will find him out on his boat. And so there was, I think, a little bit of a personal intersection there as well.
All right. And Greg, let's take a little, the opinion discusses it, but can you tell us a little about how big these charter boat fishing boats are, what they do, that sort of thing down in the Gulf?
I'll take a crack at it. As I mentioned, I'm really a landlubber, and I've only actually been on one of these boats once. And on that particular cruise, I was virtually useless. I was essentially the ship's poet, So with that caveat up front, most of what I know about these vessels, I learned in the opinion and working on the case. But generally speaking, they're 20, 30 feet. The cruises accommodate, I think, 6 to 8 people. They go out for 4 or 5 hours into the Gulf and fish and enjoy nature and fresh air and the sunshine and the sea. and then come back with their fish. And it's not that much more complicated than that. They're essentially mom and pop businesses. I think is a fair characterization of them. They're small companies. They're usually family run or extended family, that kind of thing. And they're part of the culture, as you mentioned down there. People like to do it.
And so when we were doing this case, we were trying to get stays, and Greg and I were talking when the district court decision came out by Judge Morgan. You had some concerns. I think you reread it recently. You had some concerns when you looked at it about her view of, what they could do to you in that case, like what her view of the Fourth Amendment.
Oh, right. Yeah, I thought it was. I was a little bit disappointed that it didn't seem to weigh as heavily in her analysis as it did as it eventually did in the Fifth Circuit.
Right, and the thing that I remember that I think also we were trying to get a stay in this case because you have to buy these VMS devices. They were going to cost $3,000, and most of these charter boats don't. They take in under 30. They net under 30,000 a year, so it's a big expense. So we were trying to get the court to stay the having to do all this expense, and we were pushing them and filing things and all this, and then the opinion comes out the day before Mardi Gras. Tell our audience what it's like to have a law firm in New Orleans on Mardi Gras.
Well, it's like having a law firm anyplace else on Christmas. It's the whole place shuts down, and the day before Mardi Gras, of course, is the Monday, Lundi Gras, and there are parades. There are huge parades the night before. There are huge parades that night. There's a general atmosphere of, we don't really need to be working very hard today because it's tomorrow the whole place is going to go insane, and the courts are generally, the state courts I think are closed for the whole 4 days. I don't recall whether the federal court is actually open on the Monday, but it's definitely closed. Even the federal courts are closed there on the Tuesday. So you're not going to be able to get into a court. Of course, you can do the electronic filing, but you can't actually get a live person on the Tuesday. I mean, everything's closed. The businesses are closed. The law firms are closed.
And it was March 1st, so March 1st was Mardi Gras. That's when the regulation was to go into effect. So no stay, and we weren't going to get one emergency one on March 1st in New Orleans. So it did go into effect, and all our clients had to buy those devices. And we moved for a stay also in the appellate court, and they didn't grant it either. And in the spin, they mentioned what happened, but nobody says, well, we found that there are all these violations, and it's very clear, but we're not going to say why we never granted the PI. In any event, does anyone, I'll just ask because I don't have any views, but does anyone have any view why maybe the Fifth Circuit would not grant a stay and then come out with an opinion like this, just different panels? Or is there something, any theories?
No. The only point that ever occurred to me was different panel. And of course, you don't really know what their thinking was. But it's more puzzling. What the state panel did is more puzzling in light of what the merits panel did.
And I've
got practice there, so I don't want to go further.
Yeah, and I'm not familiar who's on that panel, but one of the things, just a practitioner's note is just this is somewhat unique, I think, practice in the Fifth Circuit, which is in other circuits I practice, you're much more likely to have what's called a must panel case once once a motions panel has done the work of doing sort of the first look at a case, oftentimes they'll maintain that case. Whereas my understanding is in the Fifth Circuit, that's far less common. The motions panels dispense of those particular things. They don't tend to maintain jurisdiction of those cases. So you're much more likely to get that, one panel hearing your extraordinary early relief and a second panel hearing the merits.
Yeah, that's as good as I've heard, so I appreciate that. So, I should mention, not only did Buckeye put in an amicus brief, but we also had PLF, Pacific Legal Foundation did, and the states of Louisiana, Alabama, Mississippi, and South Carolina put in, because they thought they also regulate the boats that go fishing, and they thought this was too much. But one of the things that's come up in the amicus briefs is this idea. So in the Fourth Amendment area, there's been sort of two strains of thinking by the court. One is the invasion of privacy, that your privacy is being invaded, and what the Fourth Amendment is supposed to stop is invasions of privacy in your person and your effects. But the other is the trespassory theory. This is when they come onto your property or your effects and do something. And there was a case called Carpenter, which was about the police putting a GPS device on your car without telling you and tracking you around, and we relied on it pretty heavily. And I'll ask you, Rob, do you have any thoughts about this split of trespassory versus privacy? I think the court said this violated both, but the reason I bring it up is because the district court got rid of we had a Fifth Amendment takings claim. She said it hadn't been pled correctly. So there wasn't that, you've taken this area of the boat there, but there was a trespass idea. Do you have any thoughts on the court's split on these two themes?
Yeah, no, and I think it's one of those things. I mean, the old rule was more the trespassory rule before sort of the.
And what do you mean by old?
Pre-mid 20th century, the rule really looked at these questions. And so, I mean, you think even about some of the old wiretap cases, and they were it was very technical. It was, were they in fact invading your wires? Whereas, you then had interesting questions come up where what happens if you're using a phone booth? And so that's where, for instance, in cats, you had this sort of transition. It's less about the property, it's more about the person. It's more about the expectation of privacy of the individual. And I think there was this view in the law that had sort of superseded the previous doctrinal notions with regard to trespass. And the Jones case, which involved, sort of placing the GPS device, there Scalia said, no, the trespassory theory, that still applies, and we're going to give that force. And so I think to a certain extent, I would argue in some sense, the trespass and privacy theories merge at times, and in your case, I think that's a really good example, where the trespass is such that you're tracking or that raises privacy concerns, but it also raises concerns that you are physically trespassing on the person's car, on the person's boat, and to the Fifth Amendment claims. I mean, I think there's some interesting. I would look at Sorry, this is my frustrated former law professor coming out. This is the question: does this look more like a license plate, or is this like a cable box in Loretto? So the Loretto case involved cable companies installing cables in certain junction boxes on apartment buildings. And the trespass here was relatively de minimis. I mean, pretty small boxes on the roof of buildings. You weren't going to see them. And this really was, sort of, I think, sort of the shift to some of the per se takings doctrine that you've seen from the court. Here, you're physically taking the property by putting something on it. We can talk about distinctions. What in that case it was a third party. In that case it was real property. I mean, there are some areas where you could see them trying to distinguish it. But I'd say that looks an awful lot like saying, okay, we're going to go ahead and put this GPS device on your boat, which you have to keep on your boat. And by the way, you have to pay for it, and you have to pay the monthly fees as well.
Right. Exactly. And So I did find it, and I think you're right. It overlapped in this case. They lost on both prongs, but I can see cases. If you take this case and you look at it, you can see divergences on some of the facts that Rob just talked about. Whether you do have that type of invasion or you have cats. I always thought it was funny that cats emerged. The privacy doctrine you expect when you're on the phone call in the phone booth, which we don't have anymore. You have an expectation of privacy, and I always felt they'd put a little footnote. Look, Superman changes in there. There's totally, but in any event, so I'm going to get to the something we talk about in NCLA. I'm sure you talk about Buckeye all the time, which is Chevron. Okay, this case has Chevron written all over it, and I do think it's worth it to read to the audience footnote 3.
Yes.
From this case, and I'm going to put on my glasses to do that.
It's just art. You know what I mean, footnote 3. I mean, I want to send a big old heart to footnote 3.
Yeah. So Judge Elrod put down and I won't go give all the cites. I'll just go just the one that's important at the end. The concurring opinion, that means Oldham's opinion, would jettison the Chevron framework. Yay! And simply apply the traditional tools of statutory construction to analyze the issues presented. Indeed, the opinion conjures up Chevron as, quote, the Lord Voldemort of administrative law. To be sure, Chevron has been something of the precedent who must not be named, left unmentioned by the Supreme Court in 2 recent decisions addressing the reasonableness of agency action. And those are 2 cases against Becerra. And we recognize that the concurring judge and many other distinguished jurists, and as well as some who are less distinguished, and she cites her own case, have questioned Chevron's consistency with our duty to say what the law is. But lest we not forget, quote, fear of a name increases fear of the thing itself, unquote. J.K. Rowling, Harry Potter and the Sorcerer's Stone, 1998. We therefore name Chevron and apply its precedent until and unless it is overruled by our highest court. So I'll ask, who got the better of this, Elrod or Oldham?
So as someone who has to argue before the Fifth Circuit, no comment. But I will give my compliments to the court in general, and I think this reflects a shift, a jurisprudential shift that should be celebrated here at NCLA in particular. I mean, I think the old rule of Chevron interpretation had been, and here I will borrow from my old boss and former professor Richard Epstein, who described, sort of the rule with regard to deference to government entities, citing, the high jurisprudential authority, damn Yankees. The rule was what Lola wants, Lola gets. And so you take a look at this case in particular, and I think they did 2 things right with regard to it. Number one, greater skepticism as to whether or not ambiguity truly exists in the first instance, and they found it didn't. And that I think is an area where courts have traditionally gone off the rails, and to the point that we're looking at extrinsic evidence to determine whether or not there's a latent ambiguity. I mean, when you're going down that rabbit hole, you can always find something that makes clear language appear to be ambiguous. So you had that. And then second, sort of a genuine scrutiny with regard to whether or not this particular regulation fit within the delegation granted by Congress with regard to, was this reasonable? Oftentimes, again, you have a relatively cursory analysis. Here, I think they were willing to actually press and took to some of what, quite frankly, I mean, you almost merged some of the cost-benefit analysis. They said it wasn't required that you saw later in the arbitrary and capricious analysis with regard to some of the catch-all provisions in the statute. And
we'll get to that, but I think that's actually, that's absolutely right. If you're going to do Chevron, this opinion does Chevron right, if you will. Mm-hmm. It goes through it very minutely and doesn't sort of just go, ambiguity, you win, Do you want to take sides between Elrod and Oldham?
I do, actually.
Oh,
gently.
Okay.
I at least want to compliment Judge Elrod for that footnote because how wittily it set forth what she views as the court's proper role. She expressed, clearly and perhaps convincingly and colorfully what she thinks our job is here, and what Judge Oldham is saying may be an accurate predictor of what's coming down the line. She's saying, in this case, this is what my job is, and this is what I'm going to do. And she did it very wittily and colorfully. Reading these cases is not always fun. You come across something like that, it makes you smile, it makes your day, and it really drives home the point she's trying to make because she does it so colorfully.
Yeah, you might even say between Elrod and Oldham is the dispute between what the law is and what it should be. Right?
Exactly.
Anyway,
I didn't want to go that far. Yeah.
Well, and it might also be, a difference between step 0 and step 1 analysis too. I think Oldham basically said this is a step 0 case in some sense, and so there may not be as much light between them, but
I think that's right. Now, I have one question. I don't know if anyone knows the answer to this. But so Judge Oldham says why he didn't join one part of the opinion, but Judge Richmond doesn't join section 1, which is the facts. And I was like, I wonder what was in the facts that she didn't join, because she joins with all the law, all the holding. And I remember when I got it, I didn't really notice it. And then I read it a second time. I said, what did she join? Oh, the facts.
So this is reminiscent. I'm trying to remember the name of the case. There's a famous baseball antitrust case, and Justice Blackmun, sort of waxes poetically about the history of baseball for like 10 pages. And I recall at least one of the justices, Fleck, refused to join the statement of facts.
Oh, yeah, it was the rule of baseball antitrust.
Yes.
Taking it out. Yes, I recall that. It's beautiful opinion about baseball. I don't want any of that baseball stuff. All right. In any event, so I found there's certain things I found interesting. You talked about the textualism here. One of the arguments of the government is that the Magnuson-Stevens Act allows them to require equipment on boats. The court held that the equipment has to be in the service of the Magnuson-Stevenson Act, and that this VMS device didn't help you count fish. It did nothing in the service of the Magnuson-Stevenson Act, so therefore it wasn't equipment in the Magnuson-Stevenson Act. And I don't know that I've actually seen that before. I thought that might be useful to a lot of practitioners in a lot of areas, because you're often required by the regulatory authorities to do something and put something on. Now, the one we're all famous is the EPA scrubbers to take things that burn out of the air, something like that. But that obviously has a connection to what they're doing. But sometimes they want you to do things that are absolutely not within their remit of the statute. And I think this could be important for that later on, because they said it was equipment, it's a device of some sort, but it didn't help the statutory purpose. So they said, it's not equipment under the Magnuson-Stevenson Act. And I think that might pay dividends later on for other industries.
Well, and I think that goes to my previous comments about sort of the level of skepticism that the court applied, that they simply weren't taking these bare allegations. I think this was sort of a sign that, look, the government hadn't really met its burden with regard to showing that this was requisite for their enforcement priorities. And so they looked and said, look, if you're looking to see whether or not they're overfishing, I mean, let's leave aside for a minute that they constitute 0.2% of the fishing in the Gulf. I mean, you are using a sledgehammer to hit a gnat in this case. Leaving that aside, you have these declarations. You've got, with regard to the fish caught, the fish thrown overboard, what fish that they're getting. This is far more probative of what you're getting at with regard to this regulation. There's no evidence presented that that's not accurate. But more importantly, there's no evidence that this data, the data that they're going to get with regard to location, is going to actually allow them to scrutinize these declarations. It doesn't, they haven't shown why it is they need this information to do their regulatory job.
And that actually rings throughout this opinion. I think it was that oral argument too. I don't think the agency gave their lawyer much to work with, because their reasons for doing things were very opaque and very, they say many times in this opinion, the government lawyer gave us no reason for this, that, or the other thing. And I think that's because the agency didn't. I think it seems to me the agency felt that it could do anything it wanted, and it would win. It just thought that because of how little it did to explain some of these things.
Well, the old rule was what Lola wants, Lola gets.
Exactly.
May I make a digression
go
about
ahead.
the subject of oral argument? I don't know if we're going to get to this or not, but I have to take this opportunity to compliment John at the oral argument. One of the best joke drops I have ever seen in oral argument anywhere by anybody. And the government lawyer was arguing about the closely regulated industry exception and as to whether that required the industry to be intrinsically dangerous. And so he was making the point that, well, of course, charter fishing boats are intrinsically dangerous, and so that's why they're closely regulated, and that's why there's an exception to the Fourth Amendment here. And so with those words still ringing in the air, John gets up to do rebuttal, and with comic timing he could have rehearsed, said, well, Your Honors, when I go fishing, my wife says, good luck, but she never says, be careful. And the whole place cracked up. And that's art. It's very difficult to do. My compliments.
Thank you. But I will go to closely regulated in a second, but there's one, my bête noire that I cannot stand in statutory language is when the Congress just throws in and says, and you can do all these things under the statute, plus anything that's necessary and appropriate for the purposes of the statute. And you talk about Lola wants, Lola gets. The necessary and appropriate clause, there are so many sins that have been buried under the rug of the necessary and appropriate clause over time that this opinion by the Fifth Circuit made me so happy, because I had quoted some of Judge Leon's opinions that necessary and appropriate should be limiting, but he's a district court judge in DC. But now we have an appellate court that said necessary and appropriate is that I'll just read it. It's from page 10 of the copy. It says, as an initial matter, we stress that the adjectives necessary and appropriate limit the authorization contained in this provision. It isn't a blank slate to go do what you want. And then they say, for this reason, the rule is authorized by the Magnuson-Stevens Act only if it is necessary and appropriate, which at minimum requires that its benefits reasonably outweigh its costs. Now, I think this is the clearest statement I've seen in an appellate decision about that. I've seen that idea come across, but to say that necessary and appropriate doesn't give carte blanche is, I think, gonna be cited in a lot of statutes, because that's everywhere, isn't it?
Oh yeah, no, I think you see that catch-all provision oftentimes sort of tacked on, and again, I mean, this is where I think actually providing some analysis, providing some teeth, looking and bringing in the Michigan versus EPA with regard to what costs should be considered there. You were not looking simply at monetary costs, but they look at the constitutional injury. And that's where I might have even tacked on a bit more. I was thinking sort of by analogy from First Amendment doctrine, particularly when you're seeking injunctive relief, violation of constitutional rights are per se irreparable. And so I think when you're looking at the cost, that's sort of what was ringing around in the back of my head.
Let's go into it, because I'm thinking about this. I thought that the opinion left that. I've always said, because when you go for an injunction, if you have a constitutional injury, you have an irreparable harm, that part of the preliminary injunction prong is pretty much covered if you can really show you have a constitutional injury. So if it's irreparable, how are they supposed to weigh the cost? What are they going to do down the line for this? I think we're going to see more of this.
I agree. I mean, I don't see how any agency, particularly in view of how forceful the opinion was, and it gave alternate basis for the ruling. I don't see how an agency can avoid taking this into account in future rulemaking. It's beyond me. I mean, I'm not aware that there are any circuits that diverge from this analysis. So it's a pretty strong statement, it seems to me.
Yeah,
And I don't do as much of this stuff as Robert does, but
right.
It's a pretty strong statement.
Yeah, and I do think they're going to have to take, because there's a lot of things they do that impinge on constitutional rights.
Right.
I mean, even in an administrative search itself, one of the reasons we brought this case, I sometimes give talks on the panopticon, which is Jeremy Bentham's idea for a prison, which is where the prison warden can watch you at all times and then make sure you're not doing anything that's stopping your rehabilitation or being held. And this idea of the unseen watcher at all times for a prison has now sort of been expanded by the administrative state for a whole host of things: cameras, monitoring, listening devices, all kinds of things you see coming along. And I think that there's a difference in when you do something 24 hours a day, 7 days a week, all year, is different from a guy coming in to inspect that you don't have flammable materials lying around in your oil refinery, right? Something's different about that. And I think that they did kind of get that idea here, that it's a different thing, because they even use the Coast Guard. The Coast Guard can stop vessels that it has a suspicion have, drugs or guns or some other problem. They could stop your boat, but you have to devote a Coast Guard vessel to do that. The limiting principle to your liberty is the fact that the government has a high cost to go doing that. Whereas with all these listening devices and GPSs and everything, it's very low cost. And here it was no cost to them. They had us buy them, right?
Mm-hmm, mm-hmm. Right. I mean, I think the emergence of these technologies creates a momentum for them to be used. And so that's why I think we need to be constantly on guard against these kinds of infringements. But I'd like to circle back to your bringing up Panopticon. One of the areas where John and I disagreed in the conduct of this matter was precisely in the use of the image of Jeremy Bentham's Panopticon in the briefs. John would invariably want to put that front and center at the very beginning of the brief, recount Jeremy Bentham's idea about the Panopticon. And we would say, well, those Fifth Circuit clerks, they've seen this a lot. They're going to say, oh, this is so threadbare and shop-worn, it's going to be a distraction. And he would always put it back in. And I think he was right. And the reason I think he was right is because the opinion reflects that very visceral reaction to the infringement that the Panopticon illustrates. And this is the sentence in the opinion where it really jumped out at me. And in addition to the financial cost, of course, the regulation imposes a massive privacy cost, demanding the charter boat owners transmit that exact location to the government every hour of every day, forever, regardless of why they were using the vessel. It seemed to me that the court got that and is expressing the same sort of visceral distaste for the surveillance.
I think that sentence hopefully will be repeated in other cases. I really do, because it's happening so much. You were telling us about electric vehicles.
Well, I can see, this is where the question, here you have sort of the clear merger with regard to privacy and trespass. And one of the other areas where I could see this potentially happening, there's a big question about how it is we're going to fund transportation expenditures in the future, sort of maintaining roads. particularly when previously the funding mechanism had been gas tax. Well, what happens is we shift increasingly to EVs or hybrids. And so one theory is that you essentially install a black box in the vehicle and you're taxed based upon miles driven. But of course, these same devices have the capability of geolocating you 24 hours a day, 7 days a week, forever. And so it raises, serious privacy concerns associated with that.
Yeah, and I hadn't heard that, but of course, if they're going to marry the power to tax the power to watch you. Oof. But we'll see. I'll be watching that now because I had not heard that. Now, another Chevron aspect of this, which I think may have use in the future, or maybe I've just missed it in the development of Chevron, which is, so the Chevron, first they see if the statute's clear, and if the statute's clear, they don't go to ambiguity. But if there's ambiguity, unless the agency's interpretation of the statute is unreasonable, then the regulation holds. So the administration has the administrative agency has a lot of power there. And the reason they have a lot of power is they could take two opposite views of the statute, but as long as those opposite views are reasonable, the regulation stands, even if it goes from 180 degrees. If it's reasonable, it stands. But here, the court said that one use of ambiguity here would to be okay, which would then impinge on the Fourth Amendment privacy rights of the charter boat captains, and that they were going to use another rule of construction, which is you don't interpret a statute in such a way as to raise a constitutional problem. So they sort of like jujitsu'd the Chevron analysis away from the agency by doing that. And obviously, we've all seen a lot of times courts saying we're not going to interpret this so as to cause a constitutional problem. But I don't know that I've seen it so closely in the ambiguity of Chevron area that they apply it at that point. But I think it's an interesting, if you have a constitutional issue and you have a Chevron issue, to combine them, this could be interesting. So as to take away some of that agency power to just do anything it wants once again.
Yeah, no, I likewise. I mean, obviously, this would sort of the step two is where you would anticipate this, and I think we've seen the Supreme Court, under Roberts. I think you've seen an invigoration of the constitutional avoidance doctrine in general. This is something I think strategically that litigants should be thinking about in a Chevron case. It reminds me, by analogy, of some of the bump stock cases. I mean, there you're not dealing with constitutional avoidance. There you're looking at another doctrine which lends itself against deference, which is the rule of lenity. Another sort of construction doctrine that we play, which says, look, in a tie, in a criminal case, we're going to give the advantage to the criminal defendant if there's ambiguity, rather than defer to an agency's interpretation where there's liberty at stake. Here, not criminal liberty, but privacy liberty, constitutional liberty at stake, again, sort of weighing in. So I think there's some doctrinal similarities there.
There are. It's a good analogy. Well, into every life a little rain must fall, and we didn't win everything. So I do want to bring up the one thing we lost, which I thought we had a puncher's chance, but which is Patel. And the Supreme Court has basically four industries that the Supreme Court has found are closely regulated. And these are industries that the Supreme Court has said have a lesser expectation of privacy because they're so closely regulated. And they're the sale of firearms, explosives, automobile junkyards, and one other. And each time the court did this, mining. And each time the court did this, they mentioned how dangerous these things were. And so they require a higher level of government intervention to make sure, it doesn't blow up the town or whatever. So we said that in order for a business to be closely regulated, part of the test was dangerousness. And the court said, no, we're not adding that. Sure, they always mentioned it. Maybe it's part of the analysis as to whether it was closely regulated over time, but we're going to we're going to do a historical analysis of this. Is it closely regulated? Was it closely regulated? We're not going to inject dangerousness, which I thought, given the industry Supreme Court has said and what they said in their cases and the sort of logical progression of this, that they would adopt it, but they did not. They still found charter boat fishing isn't closely regulated. So we lost on that point, but we won the war. And a lot of, I think many of the amicus and many of the commentators that I've seen, this closely regulated issue is going to come up again and again, because there is a back and forth of trying to get around for various constitutional protections by calling something closely regulated. And the government's always going to take a stab at it. Here, they compared it to commercial fishing. We didn't really oppose that commercial fishing was closely regulated. We didn't admit it, I don't think, but we didn't oppose it. But the Fifth Circuit said, we're not ruling on, we don't even know if commercial fishing is closely regulated. So there's a lot of open space now after this opinion, at least in the Fifth Circuit, on closely regulated.
Yeah, no, well, first and foremost, I think that the key here is keeping the exception an exception. And the court, on more than one occasion in the opinion, cited Patel for the principle that you don't want the exception to swallow the rule. And so, if you take a look at what the district court did in this case, I mean, this was really Santiago.
Set off alarm bells all over, I think.
Oh, yeah. But this was Santiago's marlin swallowing the bait whole and dragging the Fourth Amendment out to sea.
That's Jay Carson, I think.
That is Jay
brief.
Carson.
Yeah,
Full credit to him in our brief for that. But it really, I mean, this was an exception that would swallow the rule. And so I think, despite the fact the inherently dangerous, it would have been nice to win, I think the more important thing is actually, the court was mindful of the fact that, look, the Supreme Court has found 4 exceptions. They have not added to the list since 1987. We should not be in the business of doing so here, and also being a bit more scrutinous as to what the regulated class of activity was, not putting it to all commercial fishing activity, where you've got, in this case, I mean, these charter fishing vessels, I mean, I think the analogy here is to Uber. These are like Ubers on the water. This is not like, this isn't a commercial trucking vehicle or a bus or the equivalent, which get regulated differently on the highway. This is like, a passenger vehicle that you're using, and bringing on a couple of passengers. So
I do have a question about our loss on the Patel issue. On the one hand, the Fifth Circuit rejected our argument that a closely regulated industry would have to be intrinsically dangerous. But on the other hand, they applied the test from Zadeh, which asks whether the industry would pose a threat to the public welfare if left unregulated. Would either of you please explain to me what the difference is there?
I thought it was the police power of the state being able to regulate things that maybe aren't dangerous, as in causing bodily harm, but hurt the public weal in some way that they can identify, like gambling, I would think. Something that, or I think something like that. That's what I took it to be. It doesn't have to actually cause bodily harm. That's because all those other industries cause bodily harm. I think what they're saying in Zadeh, because Zadeh was medicine, right?
Right.
It was the regulation of a medical practice that prescribed, I believe, opiates, if I'm remembering the facts correctly. So I guess those might cause bodily harm, but I think they were thinking of addiction. I think, but that was my thought. That's how I looked at it.
I just thought the Zadeh test would include something that was intrinsically dangerous.
And my guess is it probably does. I mean, I think the way I read the tea leaves, and I could be wrong on this, is that basically the Fifth Circuit wasn't saying, we're not going to create an exception to the exception for this class of inherently dangerous things, but part of the analysis may be dangerousness.
Yeah.
So we have to jump into the analysis of that rather than sort of having this threshold determination. But maybe I'm overthinking.
Well, the other thing, speaking about that, they did call the Berger test. The Berger test was how you figure out if something should be closely regulated and whether you lose Fourth Amendment. Judge Elrod did call Berger the zenith of this doctrine, meaning that it is down from its apogee and dropping. So I thought that was useful as well, because that came out at a time of Chevron. So maybe they're both were at their zenith and are fading. But I did like that was Berger was the zenith. So everything below that.
The nadir.
Exactly. And so I think that now the court said, and I guess we should note, the court did say that they're not finding that this is a Fourth Amendment violation, even though they seem to say it over and over and over, and they do all this Fourth Amendment analysis, and they say, but because this is an APA case, we're not doing the Fourth Amendment. Was that just a statement of what the law is? They don't reach the Constitution, or they certainly said a lot about the Fourth Amendment. Right?
I mean, I think that was such a strong signal to agencies that, look, we're striking this down because of APA now. But if you go back and dot all the I's and cross all the T's and do the APA stuff right, remember, they got right to the edge of the Fourth Amendment. And so I think they're saying, look, if you get the APA stuff right, don't think we're not going to strike this down because of the Fourth Amendment, because we bloody well will, is what I think they were saying. I mean, I thought the fact that I'm interested in your thoughts on this. I mean, it seems to me the fact that the court presented alternate reasons for ruling, and in I think it was footnote 9, she says, look, let me explain to you what an alternative ruling means. These are both, precedent going forward. Both parts here are precedent going forward.
Which is not true in all circuits.
Mm-hmm. Oh, it's interesting.
So it's true in the Fifth Circuit, but sometimes it's not true, and I think that's why she's putting in there to remind everybody, I think.
Yeah, so it seems to me that fortifies the signal they're sending here, that this is really distasteful to us, and it's really wrong, and don't do this again. It's a trip to the woodshed.
Well, I think so, and I think if it's not a Fourth Circuit ruling, it's certainly as close as you can get without being one. But I have one last, I think we have time for one last question, which I haven't really talked about the APA because the constitutional issues are so big in this, but there was one thing that she said that I think does bear some repeating if you do any APA work, and this is on the commentary. We also challenged certain material that they were collecting from these charter boat fishermen that the proposed rule didn't say anything about. It said, and other information, and socioeconomic information. And then when that rule came out, it was detailed. You have to have the amount you paid for gas, how many people, what did you pay, what did they pay? And then also they said that we couldn't have known that anyone was complaining about the Fourth Amendment privacy issues. And she just took them to task because she said, moreover, the personal privacy concern is obvious from the invocation of the Fourth Amendment. The Supreme Court's corpus of Fourth Amendment case law on warrantless government surveillance is legion. And then she cites a legion. And then she says, the assertion that the government failed to identify this particular concern from the public comments borders on incredible. And I think that is really good for the future because they like to make these vague proposals and then they come out with a rule that really bothers you when you didn't know it from reading it. And she said, lay people have to understand this. These comments aren't for lawyers, they're for lay people. And I think that's a good ruling as well, and I wanted to point it out. But I'd like, if you could, each of you to sort of sum up, to take away from the case, anything I failed to mention, and I'll start with you, Greg.
No, I mean, obviously, it's a huge victory for privacy interests. The court. One of the points that I did want to mention is the way you touched on it, that the privacy interest is different from security. Just because the government is going to, if they obtain the information from you, and say, well, don't worry, we're not going to give it to anybody else. That doesn't cut it.
And that is interesting, because that's what the government said. The government said, don't worry, we're keeping this all to ourselves, but they're going to share it with the state commissions on fishing. They're going to share it with any police who want to take a look at it. It's not, there's really no protection. One of the things that our clients always talk about is how all these guys retire from NOAA, and then they go out and start a charter boat company, and they have all the information of where their holes are for fishing, all that they've done. And so they're inside, the calls coming from inside the house, like the horror movies tell you, because they're there. They're going to take it in, and then they're going to go out and be a charter boat with all the information you just gave them. So that is important. They said, don't worry, trust us. We're the government. We'll keep it all secret. And there's some skepticism in the charter boat community as to that.
I got to say, I also enjoy, and this is sort of the sort of enjoyment of reading a case. I was struck by how often they had to parse out what words mean. There were a number of points where it was really important to figure out, so what does socioeconomic mean? What does necessary proper mean? What does equipment mean? That sort of thing. I thought that was, and of course the socioeconomic one was probably the key one. And in query, would whoever drafted this material have achieved a different result in this case had they actually used the word economic instead of socioeconomic? I think maybe yes.
Or even as such, economic information, such as what you charge on your boat.
I mean, I think whoever wrote it actually thought that socioeconomic comprised economic, and so of course it's all in there, and it was touching, from a textualist point of view, that both the district court and the Court of Appeals, ran to the dictionaries. What do the words mean? And it was disheartening, however, that they both went to the dictionary, but they came out with different results.
There is that. Rob, final thoughts?
Well, I can't do better than Hemingway, who said, somebody just back of you while you're fishing is as bad as someone looking over your shoulder while you write a letter to your girl. So the privacy interest here is clear. I think your opening question with regard to trespass versus privacy, I think this really actually brings those two ideas together doctrinally, and I think that's important. I think it sets a stage for, I think, some future challenges as well as we look at these issues. And we now have the device question, but I think increasingly, one of the questions is, as you drive down the cost of surveillance equipment, what new and innovative ways are we going to see? And so for fans of 24, Chloe, always pulled together, as the tech person on that show, and she pulled together all these various different streams of information, and that was sort of incredible at the time. But increasingly now, you've got the ability to vacuum together this information, and it becomes more credible. And essentially, in the Jones case, Scalia reserved that question, which was to say, sure, it's a problem here because they've attached something to the vehicle. We're not looking at what happens if they assigned various agents and used various technologies and so forth to surveil you 24/7. That would be a different question. And that may be a question that we'll have to deal with.
It's true. I often say that it's not just the surveillance, it's also the algorithm that can then collate everything. The algorithm and the panopticon. But I think we're going to take
Fifth Amendment. You want to make a?
Let's see about the questions. I think it's question time. So why don't we see if anyone has a question here in the audience?
How about the Loper Bright case? Is there some a discussion there that?
Well, the First Circuit doesn't think so, but I'll just tell you this. So, and I see we have Ryan Mulvey here, who has. They have a petition for cert in Loper Bright, which is a case whereby on commercial vessels, they put an observer on the boat. I'll call it an observer, and they're making the fishermen pay for it. Although the statute doesn't say that they have to pay for these observers, it just says there has to be observers. I will say this: necessary and appropriate appears, and they use that in the argument in Loper Bright. The DC Circuit used it. It's a Chevron case, so there's plenty of Chevron here. We put in NCLA put in an amicus brief there, and we certainly believe that the Chevron approach of the DC Circuit was wrong on just about everything, but particularly on necessary and appropriate. Again, it's a limiting doctrine. It's a limiting language, like it says in this case. The issues are different in Loper Bright to a large extent, but the Chevron analysis and the APA analysis are not different, and I hope that the Supreme Court looks at. I hope they take the case. It's just they just took it up for conference on Friday, I think. So I'm hoping that they take that case, but I do think that it's not clear to me that the circuits are doing the same thing with the Magnuson-Stevenson Act anywhere, because the First Circuit and the DC Circuit are using it differently than the Fifth Circuit is, or the Ninth Circuit. So these are the main fishing circuits, I would say. So it would be nice to get them on the same page, which would be the Fifth Circuit's page if I have my way.
Whether you expect the government to file a certiorari petition from your Fifth Circuit victory, and if they don't, what controls is this going to put on the government regulation of fishing here on after?
Now, that I don't believe they are, and I'm almost certain, because like a couple of days afterwards, right, we called up, they turned off everything. They told everyone you can turn off, they sent out a book, you can turn off your VMSs. They're not even using this app. We did not protest the collection of fish, how many fish you caught, that sort of thing. We didn't even oppose it, but the whole rule fell. So even that, I think they're working on getting something like counting the fish, which nobody ever opposes counting fish. So I think they're doing something like that, but the whole rule fell because they jammed everything in this huge final rule that had everything on earth in it. And so they're not going to petition for cert, I don't believe. And I think there's a couple of reasons for that. Number one, this is a pretty strong opinion. It belt and suspenders every part of it. You'd have to the Supreme Court would have to take it.
That's the point.
Yeah,
It's belt and suspenders.
And then they'd have to take all this APA stuff. So, so I do think that that they're not going to petition for cert. Any other questions?
Is there enough here for us to feel good about the cutting back on suspicionless search in all areas? I mean, you guys talked about the fact that there was a closely regulated piece of this that made the administrative state think that it could go further than normal. Is there anything here that helps for all of the suspicionless search, all the ways? I'm personally, Keith didn't mention this, but I'm thinking of course, our automatic license plate reader cases down in Florida, things like that.
Well, I'll. Anyone else have a response? I have one about. I think if you're in mining, explosives, or selling firearms, I don't think this case helps you that much because they are closely regulated and there will be precedent on that. But I think it does help in that. I mean, the Fifth Circuit has said there'll be 3 feet of snow in Baton Rouge before they find another closely regulated agency. So I don't think that will expand. But as far as suspicionless searches, they're not supposed to be any now, are there?
Yeah, no, I think for the most part, I mean, I think it closes the exception. I guess the other bait, it doesn't really touch on this. I guess the question is, would we see any extension of the doctrine into, some of the administrative proceedings, which they don't even consider to be searches. So like, you've got a licensure sort of thing, and we're going to come in and do a health and safety inspection. Some of those sorts of things. I doubt that this goes there, but it certainly at least takes a doctrine, which I think was probably at the edge of the law and prevents it from we had seen some mission creep here. The Supreme Court only recognized 4 exceptions, but some of the other circuits had recognized other exceptions.
And the lower court was about to make charter boat fishing closely regulated. So yeah, it did cut that back. But I do think that that health and safety inspections by states, I think, will be the last to fall, because restaurants expect that once a month somebody's going to come in and see how many cockroaches they got and stuff like that. So I think that some of this, and was that a search or not? Boy, it feels like it to me. But I do think that they won't be 24 hours a day, 7 days a week. The force of how much watching you get has, I think, diminished, at least in the Fifth Circuit. But I think that the reasoning of this, the fact that the government didn't have anything on the other side to buttress it, they weren't even counting the fish. It's almost like Han Solo. They didn't even ask me any questions when they got done torturing them, right? So this is the same sort of thing. They didn't even ask me about the fish. And so I think that that's part of what's going on here. They're going to have better reasons, maybe a reason associated with the statute they're supposedly enforcing, at least. But all of these at least sharpen the mind and diminish the amount of civil liberties they can go in and violate with an expectation that what Lola wants, Lola gets.
Well, you may have actually convinced me on an area where it could actually limit things in the health and safety context, which is to say, I mean, while it doesn't expressly apply, one question would, so you send in the safety inspectors, but I think this would actually potentially chasten a governmental entity that was like, okay, to save money on sending in the inspectors, what we're going to do is require you to install a camera on your property to monitor certain. I'm guessing that might be a harder sell after this case.
Yeah.
I'd like to give credit to Kate Clark, our associate, for this point. She observed that we're used to giving our data over to private companies now, over and over again. Helpfully, this case sends the signal that the government should not presume that we consent to giving our data to them as well.
I think that's right. I hope that's right. So, all right. Well, I want to thank our guests for being here today. Greg, Rob, thank you for coming.
Thanks for having us. It's been a lot of fun.
Thank you.
It has been fun, and I appreciate it. And I'm going to, I hope that that you'll be here the next time. And on behalf of the New Civil Liberties Alliance and our panel, I want to thank you all for attending this Lunch and Law program. The surveillance state suffers defeat. No, it's not legal to track Americans 24/7. Be sure to join us for more NCLA events coming in April and May, including discussions of ESG policies, state-sponsored censorship, and unconstitutional regulations like banning gas stoves.